Shopping malls are really great places to go to. You can have a lot of fun with family, friends, unless you're being threatened with arrest. We're going to talk about a case like this involving religious freedom in the second part of this program. But the first part of the program, I want to talk about something very, very important, particularly to the pro-life movement and protection of the unborn. There's a very important case pending before the United States Supreme Court. And to talk with us about this case, we have with us on the line the Chief Counsel for the Pacific Justice Institute in our Sacramento, California office, Kevin Snyder. Kevin, welcome to the program.
Good to be with you, Brad.
Now, Kevin, this is a very important case. Tell the audience what this case is about.
Well, this is a case involving restrictions on abortion, and it is a case called June Medical Services versus G. And what happened was in June 2014, the Louisiana legislature passed a law called the Unsafe Abortion Protection Act, which required that every physician who performs or induces an abortion should have active admitting privileges to a hospital located no further than 30 miles away. That was in case something bad happened, they could get this person over to get some proper medical care.
Yeah, I mean, that really makes total sense. If you've got someone treating someone with an abortion, sometimes they not only kill the unborn, but they also can threaten the life of the mother of that unborn child. So it's only logical, I think very rational, for there to be a requirement that allows that abortionist doing that procedure to be able to go to a hospital and make sure their patient has access to the kind of services in case an emergency happens, and this does happen. It does cost lives. So I think they had a really solid, rational basis, which is really all they need. And yet, something similar to this, I understand, was struck down coming out of the state of Texas. Tell us more.
That's right. And there was a case very similar, almost an identical statute coming out of Texas, and it was a case that went up to the Supreme Court called Whole Woman's Health versus Hellerstedt. And the Supreme Court determined that the law imposed an undue burden on women seeking an abortion. The High Court relied on a case called Planned Parenthood versus Casey, which is a 1992 case, which said that a provision of law is unconstitutionally invalid or constitutionally invalid if the purpose or effect of the provision is to place a substantial obstacle in the path of a woman seeking an abortion before the fetus attains viability. And, of course, that's the Supreme Court's words. So They took that law and they struck it down.
Okay. Well, how is this law out of Louisiana different?
Well, what is different is actually the makeup of the court more than the law. That was a 5-3 decision. You notice the math on that is not 5-4. Justice Scalia, after the case had been granted review, passed away. And so you had the 4 liberal justices joined by Justice Kennedy that struck down the Texas law. Now, of course, Antonin Scalia is deceased, and Justice Kennedy has retired. So we have Justice Gorsuch and Justice Kavanaugh now taking their place. And as far as, so that's the main difference is the personnel of the court. But there is a slight difference, and that is that in Texas, the facts were different as applied to these abortion clinics. In Louisiana, there would be no abortion clinics actually shut down as a result of this law, whereas in Texas that was different.
Oh, so in Texas, there would actually be abortion clinics shut down?
That's right. Okay.
So that's actually very significant. And when you're looking at the facts of it, you're still going to have the abortion clinics, the murder mills are still going to be there, still conducting the abortion procedure, killing the unborn. So they still have those clinics. There's a good chance then that this, I think, could be distinguished at the very least. Do you think it's possible the Supreme Court with the new majority may say, hey, you know what? Last time we got it wrong. We just flat out got it wrong. It's okay for states to pass laws so long as there's a rational basis to protect it. The purpose of it is to protect human life, to protect the women from not having the proper medical care they need, and in so doing, possibly reverse or overturn part of the Casey decision back in '92.
Yeah, I think they just might. The liberal end of the court sees abortion as sacrosanct, as having its own dispensation, so to speak, so that anything at all that has any limiting effect on abortion, they see as forbidden. And of course, the Constitution isn't written that way. It doesn't give heightened rights to court-made to liberties that the court simply created back in the 1970s.
Yeah.
So they may well change.
Yeah, that obsession with that part of the Supreme Court, Sotomayor, Ginsburg, for example, those two in particular, that the others, their obsession with abortion at the cost of proper constitutional interpretation, at the cost of proper application of law, their obsession with making it easy and promote it in every way, shape, form they can to kill the unborn on a massive scale is unthinkable. The idea that they will be held accountable to that once and for all, finally, if not in this life and the hereafter, that's nice, but it's not still resolving the problem here, what we're facing, which is tyranny on the Supreme Court when it comes to states like Louisiana and Texas wanting to be responsible, wanting to do what's right, not just for the unborn, but what's right for these mothers who are often easily deceived and taken advantage of by the deceptive likes of Planned Parenthood. So I think this is a very important case. Why are court watchers watching this case in particular, though?
Well, I think for one reason, abortion is a huge hot-button issue. It's believed that the false accusations against Justice Kavanaugh were raised exclusively because of fears how he might vote on abortion cases, and he's now on the court. The other reason is that this is the first case involving abortion in quite some time, and so there's a lot of interest on this, a lot of buzz.
Yeah. Oh, I can see why. And I remember that outrageous professor from California that she testified and came up with all these accusations, which evidentiary-wise were totally discredited. And then it was, I understand, alleged that she actually said earlier, before she came forward, someone's got to nail this person, or the effects on Roe versus Wade. So that obsession with abortion and wanting to make it easy to kill the unborn on a massive scale and victimize women in the process is an obsession, and yet it's a major assault on our Constitution, much less the rights of the unborn. So I think this is I agree, it's a very important case. I don't think we're going to see them reverse Roe versus Wade through this decision, though. Do you?
Probably not. Though they could do things which kick out the legs from under it, and that's what the fear on the left is, and the hope on the right is on this. And so we are, in our brief, that's what we're trying to lay the foundations for that. Yeah.
Now, what do we argue? We at Pacific Justice Institute, we're participating. What did we argue in our brief in defense of this law and that's come out of Louisiana?
Well, we filed a friend of the court brief, and we hit head on the issue of whether or not the word person in the Constitution refers to the unborn or not. And the word person appears many times in the Constitution. But what happens is the word person is sometimes modified, and sometimes it is standalone. And so in other words, the word person is used different ways according to the context. So in the 14th Amendment, the word's used twice. One, it defines who's a citizen, and that's a person born or naturalized. So that's very limited. But when it talks about equal protection and due process, it says any person. And we know that from those times, the scientific literature and the laws from when the 14th Amendment were passed the common understanding that any person included those in the womb.
Right. It makes total sense that you would recognize the unborn with, in the unborn how often, as a heartbeat, they can feel pain. There's brainwave activity. I mean, there's so many aspects to the different stages of the unborn, which evidentiary-wise would point to personhood. And yet we have the Supreme Court recognizing privately held corporations or tightly held corporations as persons for purposes of religious freedom. It's only logical that an entity with a heartbeat and able to feel pain should be afforded that same respect. I think you're absolutely right. I think there's a good chance that Roe v. Wade would not necessarily be completely overturned. They may say women have a fundamental right still to regarding procreation and in terms of termination of pregnancy. But at the same time, they may say, however, personhood for purposes of protection of life is to be decided and defined by the laws of a state, because states are the ones that have their own homicide statutes defining when something is murder. It's very logical then that they would be able to define personhood with regards to the unborn and protection of the unborn with regards to all termination of life, not just that in the murder context. So I think there's a good chance we're going to see, like you alluded to earlier, that Roe versus Wade could be actually greatly weakened, at least in terms of a state empowerment, which I think would be absolutely fantastic. It's the biggest mark on this country in years, if not since our inception, is the continued massive killing of the unborn and through the massive deception taking place through the evil institutions such as Planned Parenthood, who are not just killing the unborn but also victimizing women. This law makes total sense. And Kevin, thank you for the work that you're doing on behalf of the Pacific Justice Institute to stand up for truth and the Constitution.
Thank you.
Parents across the state are keeping their kids home from school today. They say the new sex ed program is too inappropriate, adding the curriculum sexualizes children as young as kindergarten age.
If it's in California, I know many other states are doing it as well. This is not far behind. It's going to be everywhere.
We at Pacific Justice Institute have been fighting this for quite some time.
That I didn't think was quite necessary for
if
10-year-old
parents knew
kids.
what was happening, I think they'd be
The California Healthy
alarmed.
Youth Act now requires that school districts cover topics like gender identity, gender expression, and abortion.
For fifth graders.
It's not age appropriate, it's not medically accurate, it goes way beyond the law.
If it feels good, do
This
it.
is for fifth grade as well. This is still in the framework. This is for third grade. And only they, meaning 6-year-olds, know what
It's
they
in
are.
government, it's in our medical societies, it's activists promoting
And
this.
they all said this is inappropriate. Children cannot process this information. It's harmful.
Whatever they're doing is not
This
working.
isn't the way that I would want my own children taught about something as important as this in their lives.
So the California Department of Education still believes these books are appropriate. And these are the people that are making decisions over our
This is
children's
one of these
education.
battles in life where you drop absolutely everything and you go to the hills, because this is the hill life.
You can't teach this in an unbiased way. It's a moral
When we
topic.
tell parents, they're livid. They're angry because they want to protect their children.
We will stop at nothing to protect
Don't
our kids.
be afraid, don't be discouraged, don't be intimidated.
Parents have to be vigilant. They have to be
All you
insistent.
have to do is start educating yourself.
The districts and the staffers are very good at
Without
misleading
question, there is a
parents.
growing movement of parents across the country who are speaking out and objecting to what's taking place. It doesn't matter your race, it doesn't matter where you're from. If you've got children, you're going to care. And folks, if you'd like to support the work of the Pacific Justice Institute, it's real easy to do. Become a part of our team by going to pacificjustice.org, pacificjustice.org, or pji.org. And there you can sign up to get our Legal Insider newsletter. It's once a week. It's emailed. It gives you what to pray for, what to send out to other people so they can be aware of what's taking place. Things that the mainstream media does not want to talk about, they don't want people to know about. We're talking about it, and we're doing something about it, and we want you to be a part of that as well. And then if you want to support our work, boy, we greatly appreciate that. You can also do that on our website, either on a one-time basis or even better yet, on a monthly basis. Those of you who support us on a monthly basis, folks, you're part of our team. That's how we count those who support our work on a monthly basis. Any amount would do. So just go to our website, pacificjustice.org or pji.org. We have with us here in the studio Michael Peffer, the attorney for the Pacific Justice Institute, who heads up our Southern California office. Welcome to the show, Michael.
Glad to be here, Brad.
Now, Michael, you've dealt with a number of cases that have been serious threats to religious freedom, free speech in public places. Now, specifically shopping malls. Tell us about some of these cases where we've seen shopping malls be the Grinch that stole Christmas, if you will, when it comes to people wanting to live their faith, share their faith. Not rebel rousers, not people trying to create a big commotion. Peaceful, loving people, grandmas who want to just be able to share their faith and talk about God like they do anything else, and yet they're treated very adversely, even arrested and prosecuted like criminals. Give us about some of these stories and where we are, because this is very important for people across the country to know what could be coming to a state near them.
Yeah, this is one of those cases, Brad, where we come to you. Usually we come to you and we say, oh, this is California. Things are really bad here in California. You could do this in the other states. But in this case, in California gives people wanting to share their faith and speak in the public domain, if you will, in the better freedoms, more freedoms than in other states.
Yeah, well, there's a number of states, about a half dozen, as I understand it, in addition to California.
That's right.
That allow for people to be in private shopping malls, not in the store, not in the JCPenney's.
Correct.
But rather in the eating area, the common area, where they've got plants and stuff, sometimes birds flying, we're talking about that. About a half dozen other states allow people to have protection under their state constitution for being in what's called a quasi-public forum.
Right.
So it's not technically owned by the government, but it acts and functions like something open to the public, like the government. And yet we've seen some real hostility from some of these states where it's supposed to be allowed. Give us some examples.
Well, for instance, I think it's a big thing now because of security issues to have actual police stations within malls, and so we have found this. Sometimes that leads to greater harassment for people that are wanting to just share their faith. And keep in mind, we always tell our people, and our people are great at this, the people that come to us, don't block entrances. Don't get in where you're blocking the ingress and egress of people's traffic.
Coming and going, right?
That's right. And so instead, people, they can walk around, they can talk, ask people, hey, would you like to hear about Jesus? Or whatever, some kind of a way to get into the conversation. And by and large, these are people who have, the public has said, yes, I'd love to hear that. So here they are, they're talking to them and sharing their faith and sharing what God's doing and what God can do for them. And then the security guard comes, followed by the police department, saying, you can't talk around here in this place because we have a free speech zone, which is the size of a postage stamp out by the trash cans.
Yeah, no, it really gets that bad, doesn't it?
It really does. It's crazy.
They put them somewhere where no one's ever going to see them, and so they're trying to technically satisfy the rules. And as far as security guards, police, actually, I like them. I feel safe. You can have some crazy person there. We've seen this happen before with terrorists and stuff. And in the United States, it's unfortunate we have those kind of people, but I like security. But that doesn't mean security has to be a bully.
That's
we had a case matter up in Sacramento Shopping Mall where the security heard a gentleman sharing his faith with someone else in the eating area. They're sitting there talking together, having a conversation, dialogue back and forth. Security guard hears the G word, God,
yes.
Maybe the J word, Jesus,
yes.
And says, you can't do that. What happened?
Well, what happened is that case ended up going all the way to the California Supreme Court. And the California Supreme Court held strongly that in California, this is a quasi-public forum, which means you're at your greatest rights to share your faith, to share. It's not just faith, but we're predominantly concerned about people being able to share their faith.
Right.
You have the right to share your faith to willing listeners. And again, the anecdote has always been, listen, you could be in line talking to someone about the Super Bowl or something of that nature. Nobody's going to harass you, but you start talking about the topic of God and Jesus, and next thing you know, security is called, employees get rankled, and now we have a situation where something that could have been very easily dealt with is now in the courts. And,
I know in shopping malls, people, they talk, they converse. It's a place of social interaction. That's why people like to go to shopping malls. They're made to be very friendly. They have park benches. They have trees. They have all kinds of things inside these enclosed shopping malls. Mm-hmm. And yet, for some reason, when it comes to people sharing their faith, living their faith, that's somehow taboo in the minds of many people, many shopping mall owners. And we took on this case. We prevailed in this case. Right. It was very decisive, and it had a big impact opening the doors for other people and individuals in shopping malls in California and 6 other states to be able to do the same. What about those people who are in a state where the state constitution doesn't respect the quasi-public forum? It says, hey, this is a private shopping mall. Do they have any rights at all? And if so, what are their rights?
Yeah, listen, I don't think those people are without rights. I think that what has to happen in those situations is that you have to be a little bit more wise in terms of what you're doing, and they can ask you to leave in those states that aren't protected like this. They can ask you to leave if you are not. If you're distracting from their business, which is the line that they usually take, but you can you can go to the management and you can say, listen, what are your rules and regulations regarding talking to people about public issues or important issues? And they'll usually have that. They usually have a way to say, hey, listen, this is what you can do, and this is what you can't do. And so we recommend that people be wise and go to them and say, listen, I'm talking to someone here, and I'd like to share the things that are important in society right now and what's on my heart.
Yeah. And that's a good perspective to take. And also, if they are booted out and they said, no, we don't want that shared, they can do that. If they say, no, people like you, Christians like you, religious people like you, we don't want in our shopping mall, then they've crossed the line, because now they're discriminating against doing business with people simply because of their faith, not because they're sharing their faith, but because of their faith. And that's an easy line for them to cross. Also, I think it's important for people to know that if this does happen, and let's say they just said, hey, we don't want you to share your faith. We don't want you here, not because of what you believe, but because we don't want people sharing their faith. They still have the opportunity of the power of the consumer. That is, letting people be made aware of this. And, they can tell their story and let people know this shopping mall is a deophobic, anti-Christian, bigoted shopping mall that doesn't want people to be able to talk about their faith, doesn't want people of faith to have the same opportunity to share what's important to them and on their heart as other people who have other things like sports and other things that they want to share. So there's ways that we can actually, through the free market and just dissemination of information, can make this information effective, sometimes even more effective than a legal action. What about the public square? What about like a public park? Right. We at Pacific Justice take on these cases dealing with shopping malls, but public parks have a lot of protection too. Briefly tell us, what kind of protections do people have to be able to share their place in public parks or on a public sidewalk, for example?
Yes, well, these areas, the park and the sidewalk and other similar areas, have been designated by the United States Supreme Court as the quintessential public forum. And in what we mean by a public forum, there's ways of analyzing free speech cases, and at the highest level of freedom is a public forum. And
like
that,
a public sidewalk.
That's right. That's
Okay.
right. And so on a public sidewalk, people can readily share their faith, and they can share it with people walking by, people congregated. They can share their faith, and it can't be restricted. It cannot be restricted except in the instance of blocking the throughway or something of that nature.
Right.
So if you are not blocking the throughway or blocking the ability for people to move by you, you're fine. You're well within your rights to share your faith, and in a way that is up to you, between you and God.
Yeah, and people need to be aware that there are sometimes noise ordinances. So if they have a big bugle horn and it's really super loud, they could be violating the requirements. So if a policeman says, "Hey, you're violating the noise ordinance," they can say, "Okay, officer, what is the noise ordinance? What's the level?" If they don't have anything measuring and they're just subjective, well, they can't enforce it. I had a case in Texas where I'm licensed not only in California but also in Texas. And I represented and defended someone like that, and they said, we thought it was too loud. I said, well, did they have anything to validate that? Did they have a measurement that measures the noise? No. Well, the charges were dismissed. So there's a lot of freedom. Michael, if people wanted to know about their rights, where should they go?
Well, they can contact any Pacific Justice Institute office and speak to an attorney.
Without charge.
Without charge. And those attorneys were skilled. This is what we do every day. And so we're happy to talk to them without charge. We also have available online, we have fact sheets which discuss this issue of talking about your faith in the public forum. And so those are available online 24/7. You can pull these off, print them up. One thing we find, Brad, is that, as you know, we find that oftentimes all it takes is a letter. They hand this letter to the security officer or to the police department, and usually reasonable people will read the letter and realize, yes, these people have the freedom to be here and do what they're doing.
Right. So people just go to our website, pacificjustice.org. There you can download information to know what your rights are and be empowered. And if you need assistance, you can contact us. We do all our work without charge in all 50 states to live your faith, share your faith, including public places. So folks, there you have it. It's our God-given freedoms we're talking about. Now, let's choose to keep them. I'm Brad Dacus, president of the Pacific Justice Institute. Have a great weekend.